All right, thank you all for joining us. It looks like we have a lot of the people who registered finally online. I want to share with you all that before I go through the material today, that perhaps the title of this program was a misnomer. Really, this is about tools that you'll see advertised on the internet for ways of protecting assets, usually from creditors, but I guess to a lesser extent from bankruptcy trustees. And this is a kind of what those tools are and why most of them don't work. So it should be something like what not to do before you file bankruptcy instead of hiding assets in bankruptcy. As you all know, I'm a bankruptcy trustee in Los Angeles, and I certainly would not encourage any of you or your clients to hide assets from trustees. There's a lot of things that can happen in the event that they decide to do that. If you Google asset protection, I think a lot of you will be surprised by the quote and unquote advice that people give to people looking to shield assets from creditors. It's incredible to think that there are people, and some of them are professionals, that are out there that offer advice but have no real concept of how the fraudulent transfer laws in California and the bankruptcy laws work as far as recovering assets and liquidating assets. I think if some of them had a clue, they wouldn't be advertising, because it's very likely that these people would be out of business. This seminar may, for some of you, be nothing more than just a refresher. For some of you, this may be very useful. There are some complicated issues I'm going to get into, but a lot of the concepts today are very general. For those of you looking for credit, I encourage you to stay the whole hour. For the rest of you, I encourage you to stay for the whole hour as well, because I think there's some very good things in here for discussion. We do have the ability for you to ask questions. I will take questions at the end, but if you want to send your question to me, I believe it's through a chat during the call, I'll try to get to your question at the end. But otherwise, if you don't have any questions, then obviously just stay quiet. Okay, so I'm going to break the seminar down into 4 parts. The first is an explanation of the common asset protection tools. I'm going to give you a general explanation of how these tools work. I'm also going to note for all of you that I've done a little bit of debtor work. I mostly represent trustees and been a trustee, and that I'm not an expert in any of these areas, and that some of the things that I learned before preparing or when preparing for this seminar came off of Wikipedia. So, well, I'm only kidding. Maybe, I don't know. But some of these concepts are as foreign to me as they may be to the rest of you, but I can tell you how and why they don't work. The second part I'm going to discuss are some of the uncommon ways, or at least the less common ways, that people try to protect their assets from creditors in bankruptcy. In the third part, I will go through each of these tools and explain to you why almost all of them do not work in Chapter 7 bankruptcy. And then finally, as I noted earlier, we'll have a question and answer session to the extent we have time for that. All right, so we're going to jump right in. The first is the popular tools, the more common tools for asset protection. And the first is a trust. As many of you likely know, there are really 2 types of trust. One is a revocable trust. The other is an irrevocable trust. A revocable trust is a trust set up where generally it's the settlor, who's the party putting the asset into a trust. They serve as the trustee and the beneficiary. The revocable trust has a clause in the trust agreement that allows for the settlor or trustee to unwind the transfer of property and any kind of accumulated interest or other assets back to the settlor. In other words, these can be temporary. There's also an irrevocable trust, and that is where an asset is transferred into the trust and the settlor relinquishes all right to the asset, and it's any kind of offspring it produces, subject to certain rules. There are also a couple important trust concepts that we should briefly discuss. One is something called a self-settled trust. A self-settled trust can be trusts that are revocable and irrevocable, but generally a self-settled trust is a trust in which the settlor is also the person who is to receive the benefits of the trust res, in other words, the property and its offspring. There are also spendthrift clauses. Spendthrift clauses prohibit a beneficiary from assigning away the res or the property of the trust, and if drafted correctly, can protect the assets of the trust from creditors. The next concept is life insurance. This is the next type of tool. There are two types of insurance. One, as we probably are all familiar, is term life insurance. Term life insurance policy is only payable upon the death of the insured, not the owner. Sometimes the owner can be different than the insured. Then there is whole life insurance. This is a combination of term and something else. So it pays out upon the death of the insured during the period or term of the policy, and also contains a savings component where some of the cash, and I guess sometimes other property, can accrue and can be withdrawn by a debtor, or I guess really by the owner of the policy. The next type of tool is an annuity. Annuities are a type of insurance product which operates like a retirement account. Typically, contributions are made and are invested in securities with the payments and the taxes deferred until a certain date. Once an owner is eligible for distributions, a monthly stream of income is paid out to the owner until the contributions and any accrued interest, dividends, etc. are all exhausted. Taxes must be paid on the gain, and unlike 401ks and IRAs, there are no contribution limits. The next are retirement accounts. There are a variety of retirement accounts. A retirement plan or account is generally a financial arrangement that's designed to replace the income of an employee after they've retired. These plans are generally set up by employers, insurance companies, trade unions, sometimes the government, and sometimes other institutions. There are a handful of types of accounts that are recognized by the Internal Revenue Code as valid for tax treatment purposes. Those are individual retirement arrangements, which we call IRAs, Roth IRAs, 401k plans, 403b plans, which are for public school retirement accounts, simple IRA plans, SEP plans, SAR-SEP plans, payroll deduction IRAs, profit sharing plans, defined benefit plans, money purchase plans, and employee stock ownership plans. The next type of tool is something I call an offshore account. We're probably all familiar with the concept of an offshore account. And the term offshore account originated in the United Kingdom. The Channel Islands are technically offshore from the United Kingdom. And as lore goes, or history rather, the offshore account, as we know it today, started in the Channel Islands. So that's where the name comes from. Today, offshore accounts are typically located in island nations, and that's probably why the name has stuck. Today, there are over 75 countries which are either on islands or they are landlocked, or both, which offer offshore accounts. The list of the countries, if you look them up, reads like a wish list for sun-seeking travelers. I hope that my partners agree to pay for all of my trips to these different island resorts, areas, so that I can check out on the banking institution and practices there, so I can become more familiar with this as a trustee. Offshore accounts traditionally refer to secret accounts that are held by foreign nationals in countries that provide secrecy and sometimes tax advantages. The most common, or probably well known, is the Swiss bank account, something out of a James Bond movie. It's a secret account, 2 keys, you know the whole story. There's also Cayman Islands. That's more of a common type of place where you can get an offshore account. And then another, which is more interesting, would be the country of Panama. And we'll explain in a bit why Panama might be an interesting angle. Also, there's another thing that I thought of would be a gambling site. Most gambling sites these days are offshore, and those accounts are held offshore. And they are treated, as we will get into this, more as like an offshore account than anything else. The next tool, common tool, would be a business entity. There are corporations, limited liability companies, and partnerships and LLPs. Each of these is commonly noted by these asset protection experts as ways of keeping assets safe from creditors. Finally, and this is the most baffling to me, is that you'll find some of these websites offering asset protection suggest that you transfer your property to relatives and friends. That's a direct quote from one of the websites. Finally, similar to transferring money to or property to a third party, there are 529 plans. And as most of you know, a 529 plan is a savings plan designed for future college costs, for payment of those costs. And technically, once the property goes into the 529 plan, it becomes property of the student and not the parent. There's also something of note that I learned this week is that there's a maximum contribution in California to 529 plans per child, and that's currently $371,000. All right, we're going to move on to the less than common ways of parties and people try to keep assets safe. The first is a post-nuptial agreement, which is really a post-marriage transmutation of property done by an agreement. In California Family Code, it allows for spouses to transmutate property post-marriage and treat community property as separate property. It's perfectly legal. I think a really good example of this was the Frank and Jamie McCourt post-nuptial agreement that hit the papers. And it looks like what Frank and Jamie did was they moved all of the assets from Frank and Jamie into Jamie's name as separate property, and this includes real estate, bank accounts, and shoes. Surprisingly, shoes was mentioned in one of the articles I read, as well as any other assets that they held. The only asset that Frank retained was the Dodgers. Another uncommon tool is marital settlement agreements. And frequently, in marital settlement agreements, it's already to the point where the parties have divorced. The spouses have divorced, or at least inter-divorced, and then assets are divided by agreement through the proceeding. And there's an agreement drawn up which designates who gets what. And sometimes in these marital agreements, there is an exchange of an asset for a requirement to pay support. And this is an important thing to note. I'll get to it in a little while. There's case law on this. And then finally, sometimes assets are divided by the court itself. The next uncommon asset protection tool is something called a Domestic Asset Protection Trust, or DAPS for short. And a DAP is an irrevocable trust that's established and it really is only available in a few jurisdictions, a few states, but it allows the settlor of the trust to be a discretionary beneficiary and apparently protects the trust from settlor's creditors. Really, it's just another form of a trust. Unfortunately, in California, it's not something that's enforceable. Bitcoin. Bitcoin is one of my favorites. It's something that is now becoming very popular, and it's a form of digital currency that's created and is held electronically only. Although they do produce token Bitcoins, the currency really is electronic only. Apparently, Bitcoin is not controlled by anybody. At least that's the way the website touts Bitcoin. The amount of Bitcoins that are in circulation will remain finite, and because of this, they're supposedly not affected by inflation. But the Bitcoin value does fluctuate like a security, and it's also important to note that Bitcoins can be earned by individuals by doing mining. In other words, what that is it's a task of solving a complex mathematical problem that helps keep a general ledger of all transactions using Bitcoin, and they call these blockchains, for all users. And the most important aspect of Bitcoin is it advertises that Bitcoin is held anonymously and transactions are anonymous. One of the next uncommon ways of protecting an asset of sorts is an unrecorded deed. And this is really simple. When property is inherited or to be transferred to an individual, and the individual feels that there is enough equity in the property that it could be levied or foreclosed upon by a creditor, the transferee holds the grant deed, doesn't record it, and waits for a while, and then records it down the road. Finally, my favorite one. This is new. Retirement plans that hold property by virtue of a default on a promissory note. And I apologize, I was supposed to be moving the screen. Let's see where we are. Okay, What this is a tool that involves a shell corporation that's formed by the debtor or an individual, and the shell corporation creates a private retirement plan. The retirement plan document is about 50 pages long, and it looks like a real retirement plan. However, the plan is very specific that it does not comply with IRS regulations and will not comply with IRS regulations. So this plan is drawn up, and the debtor doesn't actually fund the plan with cash contributions or salary deferrals. The only funding of the plan is that the debtor signs a promissory note that obligates the debtor to pay a certain amount of money to the retirement plan. And to secure the obligation to the plan, the debtor signs a deed of trust that pledges the property, and it's usually the debtor's home, as collateral. After never making a payment on the loan, which I'm pretty sure is intentional, the debtor avoids foreclosure by signing a deed in lieu of foreclosure, which transfers title of the residence into the retirement plan. Voila! The house is now property of a private retirement plan and presumably exempt from any kind of creditor collection or trustee. All right, so those are the types of asset protection tools that I found. There might be other ones. So let's get into now why most of these tools do not work. The first is trust. As we discussed at the very beginning, there are two types of trust, revocable and irrevocable. And under California law, a revocable trust is property of the estate for bankruptcy purposes. And the reason is because the settlor of the trust retains the power to revoke the trust, which would then return all of the trust property to the settlor. And when a case is filed, the trustee becomes, or at least steps into the shoes of the settlor if the settlor is the debtor. So with that concept in mind, what happens with revocable trust is the trustee can revoke the trust and the property becomes property of the estate. A revocable trust is no protection from liquidation of property in bankruptcy. And by the way, if you'd like citations to anything I discussed, almost everything in my discussion today is supported by case law or statutes. I'll try my best to refer to some of the statutes, but it's a lot of material, and I don't think we have time to do that. Okay, so irrevocable trust. These are a little bit better for purposes of keeping assets protected. And it generally held in a trust by a debtor for another party is not property of the bankruptcy estate under 541D, nor is it considered property of the debtor in general. But with that said, assets transferred to a trust do not ordinarily become property of the bankruptcy estate unless the power of the debtor to run the trust remains with the debtor. And there's also another part of it where the debtor is the beneficiary. So what I mean is, if the debtor is able to direct payment, frequently that's enough to make the trust, part of the trust at least, property of the estate. And more commonly, it's where the debtor is the beneficiary, even if it's an irrevocable trust. If there's no proper spendthrift provision, which we'll talk about in a minute, then the res of the trust, the property of the trust, does become property of the estate. Okay, so the other two concepts with trust are self-settled trust and then the spendthrift clauses. A self-settled trust is a trust, as I described earlier, where effectively the settlor, which most likelihood is the debtor for purposes of bankruptcy, the debtor transfers property into the asset, or the trust rather, and retains the rights, or it becomes the trustee and the beneficiary. Assets of a self-settled trust become property of the estate because of 544A1 and A2, along with certain provisions of the California Probate Code. So 544A1 gives the trustee the status of a creditor with a judicial lien on all property, which a creditor on a simple contract could obtain a judgment lien. 544A2 gives the trustee the status of a creditor with an execution against the debtor that is returned as unsatisfied. And then there's California Probate Code 15304, which allows creditors to reach the maximum amount that the trustee of the trust could pay out to or for the benefit of the settlor. So, and finally, the transfers to a self-settled trust that are made where there's no value of exchange, which is almost always, are subject to the avoidance powers of a trustee under 548 and under 3439.04 and 05. So the way these things work together is that property put into a trust, especially a self-settled trust, can become property of the estate, and if they don't automatically become property of the estate, they can be, the property can be recovered under 548 of the Bankruptcy Code or Section 3439 of the California Code. It's also noteworthy that for self-settled trusts, the look-back period, the period of time the trustee has to avoid the transfer, is 10 years, and that's found under 548E. Okay, spendthrift clause. Probably the most important thing that we need to know about a trust if it's not a self-settled trust and it's an irrevocable trust. And as I may have noted earlier, California law recognizes that spendthrift trusts are valid and the clauses are valid. But the problem is sometimes spendthrift trusts are merely words on paper. And really the inquiry in deciding whether or not the trust is valid under California law is to examine the control of the trust or the trustee's beneficiaries, or sometimes the trustee, usually when they're the same. How much control do they have over the use of the res? And why this is important is that California law doesn't allow a participant, so a trustee or a beneficiary or both, where to shield assets in a trust from creditors, even if there's a spendthrift clause, if the spendthrift clause is nothing more than something on paper. So really, this is just a fact-specific examination that has to occur to decide whether or not a spendthrift clause is valid. And of course, if it is valid, the res is protected from the bankruptcy estate and the trustee. If it's not, then it's likely some, if not all, of the res of the estate, of the trust rather, can be brought in as property of the estate. So trust can be very useful if you're going to try to protect assets, but the issues that always will arise are A, the transfer of the asset into the trust and whether or not it can be avoided, B, whether or not the trust is revocable or irrevocable, C, whether or not the trust is self-settled, and D, whether or not a valid spendthrift clause exists. Under the right circumstances, assets put into a trust can remain property of the trust and will not be subject to liquidation by a trustee. All right, the next type of asset protection tool is life insurance. Whole life insurance, it's fairly simple. The cash value of a whole life insurance policy can be liquidated by a bankruptcy trustee because it is property of the estate. The only exception would be if the debtor has a validly claimed exemption against the cash value of the property. And whole life insurance, the cash amount can be liquidated even if there's an early cash out penalty or some other restriction. Most life insurance policies with the whole life insurance component, which has cash, becomes property of the estate because it is not, unless certain circumstances exist, which I'll talk about in a minute, because it is not shielded because of the way the insurance policy is structured. There's also term life insurance. Term life insurance, surprisingly, is something else that parties are willing to buy these days. And although the transfer can be complicated, the actual rights to the policy, if the debtor is, specifically if the debtor is the owner and beneficiary, can be transferred onto a third party for cash. So if you're filing a bankruptcy for a debtor, you need to be wary of this and, if possible, exempt as much as possible of both a term life insurance policy and a whole life insurance policy. The next asset protection tool is a 401k plan. And these are pretty straightforward. 401k plans in general are absolutely protected, but there are a few pitfalls. First, you need to recognize that a 401k plan needs to hold assets of the debtor, and the assets must come from the debtor's employment and maybe the debtor's spouse's employment. If it comes from a third party, that's not income earned in the course of the debtor's employment, and therefore may not be protected by an exemption. Also, it's noteworthy that 401k plans are a form of a trust. So, similar to what we just discussed about trust, the debtor can't be the trustee and beneficiary. Otherwise, it could be a self-settled trust. And typically, most 401k plans, there's a trustee involved, and that's the administrator of the plan. Usually, they have somebody serve as trustee. Never is it the debtor. But occasionally, you'll have debtors who create retirement plans on their own, and they may serve as their own trustee and beneficiary, and this may not protect that asset, the res of the 401k plan, from liquidation by a trustee. So there's a couple other things on 401ks. There's also something you need to know. This would probably go hand with the debtor being in charge of the 401k as serving as trustee. The debtor has unfettered access to money, or can change or modify the maturity date. Those two are red flags. Those likely render the res of the property not exempt for purposes of using a retirement account exemption. But for the most part, 401k plans are a very good tool for protecting assets. The way they are funded and the way they are held generally keeps them from being liquidated in bankruptcy, but be careful of the pitfalls that I just identified. IRAs. IRAs are interesting. There is a case that came out a few years ago. It's called Clark v. Ramaker. And in that case, the U.S. Supreme Court held that an inherited IRA, which does not contain funds that were accumulated by the debtor from his own income, does not qualify for an exemption. And if you read the decision, you'll understand how the Supreme Court came to this decision, because IRAs technically, for purposes of tax treatment, need to be they need to hold money earned in the employment of an individual, and sometimes it can also hold property of an individual, but that's something separate. There's one exception for inherited IRAs that we know to exist in California currently, and in fact, Clark v. Ramaker pointed it out, is that if the owner of the IRA dies and leaves the IRA to his or her spouse, then the spouse has a choice. He or she can roll over the IRA funds into his or her own IRA, or he or she may be able to keep the IRA as an inherited IRA. Although the court's notes in Ramaker are really just dicta, Ramaker suggests that a spouse who elects to roll over the funds into his or her own IRA should be able to keep as exempt those IRA funds as retirement funds. But if the spouse leaves the funds in the inherited IRA, that spouse is at risk of having the funds levied by a creditor, or if the bankruptcy is filed, from those funds being liquidated because they are not exempt. And similar to 401ks, IRAs are treated as trusts. So also be wary of an IRA that somehow is controlled by the debtor, where the debtor is a trustee and the beneficiary. Annuities. The next is annuities. And there are two decisions in the BAP that say annuities generally are not exempt. But annuities can be exempt so long as the property in the annuity, which usually is cash, is invested in ERISA plan qualified retirement tools. So in other words, the annuity is really serving as a 401k or an IRA or something like that, like profit sharing. If it's just purely an annuity where cash is put in and over time cash is paid back, but the funds are not invested in something that's qualified. In other words, the annuities are just invested in Bank of America stock, for example. Those types of annuities are not exempt. Also, life insurance policies, or I guess life insurance really can be an annuity also. But the rules on life insurance are similar to the rules for annuities, that you have to meet all of the requirements for life insurance policies to be exempt to the extent they can be exempt. Offshore accounts. I learned this week that Swiss bank accounts no longer take money from the United States, citizens rather, or even those that live in Switzerland who are United States citizens. And this is because of something called the Foreign Account Tax Compliance Act, or FATCA. And this act requires that foreign banks that operate under the laws of participating countries, they need to disclose the account holder information to the United States for all U.S. citizens holding money at their banks. And so Switzerland has agreed to comply with the act, but because they're complying with the act, they don't want to take money from U.S. citizens any longer because now they have the duty, the affirmative duty, to disclose the information of account holders to the United States. Now this might be changing. This was something that I learned of recently, but it's interesting that the old James Bond Swiss bank account may not be something that U.S. debtors can use any longer. And also, so FATCA now has several members in it, which all will honor the United States requirement that account holders' names be disclosed. And those countries are France, Germany, Italy, Spain, Japan, South Africa, and the United Kingdom. So one of the offshore account countries that I noted earlier that's of interest to me and maybe to you is Panama. And here's why. Panama has managed to, I guess, resist the U.S.'s pressure to become one of the members of FATCA. And the reason they seem to be able to do that is they provide a key strategic, I guess it facilitates commerce, and that's the canal. Panama is so heavily relied upon by the United States for use of its canal that somehow it's managed to leverage that usage into keeping out of FATCA. So apparently Panama might be, I'm not saying it is, but it could be a place where money could be held and account information not disclosed. However, as most of you probably know or have heard, there's something called the Panama Papers. And what this was a group of journalists did some investigation, and I don't know how they obtained it, but they obtained information for 11.5 million different account holders in Panama, and then they disclosed that information. So all those people who were hiding money, and maybe they weren't hiding money, maybe their money was just stored in Panama, were outed. And I think a lot of them are going to be in serious trouble with the IRS, as I have serious doubts that they've been recording and reporting their income. Also, the IRS has something called a qualifying intermediary rule, which requires that the names of recipients of U.S. source income for investment purposes, that information needs to be passed to the IRS. And also there's something called the Bank Secrecy Act, and that requires U.S. citizens to file an FBAR for accounts that are outside the United States. So all of these different laws are making most of the traditional offshore accounts now, they're transparent. And to the extent that the information can be obtained from by the IRS of the U.S., that information could theoretically be obtained by a bankruptcy trustee. So be wary of that. If there's money offshore, that money may not be hidden. Rather, it may be easily discoverable to the extent that the trustee is tipped off that money is held in an offshore account. Also, gambling sites. Gambling sites, you put money in it and you bet, and I guess in theory you could hide or put money into these accounts, but it appears that a lot of these gambling sites they exist on islands that will allow for disclosure or at least follow the intermediary rules and the Bank Secrecy Act, and they may out you if you have money hidden there. So gambling sites seem to operate just like a regular offshore account, notwithstanding the fact that they are really not an offshore account, but they are something different. Business entities. This is one of, aside from trust, this seems to be the other really popular one on the internet. And so corporations, it's important to note that if the debtor holds the stock in the corporation and all of the debtor's assets are in the corporation, well, the stock becomes property of the estate. And if necessary or possible, the trustee can vote him or herself in as the director, potentially as officers. And so what that does is that if the trustee has the ability to put him or herself in, then the trustee has a variety of options that he or she could use to liquidate the assets in the corporation. One would be to file a bankruptcy petition, file a Chapter 7 case. That would put another trustee presumably in as the liquidating trustee, and the trustee would sell the assets of the corporation and tender over the remaining money to the trustee of the individual estate as the equity holder. Another would be that the trustee could file a lawsuit for involuntary dissolution of the corporation, and any proceeds received at the end of the involuntary dissolution, presumably this is a corporation with no debt, it's just holding assets, well, those remaining assets would be paid into the bankruptcy estate. The trustee could also seek a receivership. The trustee could also do an assignment for benefit of creditors. And finally, the trustee could, if the facts or the debts wind up, could file a motion for substantive consolidation and consolidate the assets of the corporation into the debtor's individual case. That's a very difficult and technical thing to do, but it is possible. Moving on, LLCs. So LLCs operate similar to corporations for purposes of asset protection. And again, the trustee could vote him or herself in as the managing member, assume managing member duties subject to potentially state law and some of the operating requirements, or I guess operating restrictions that might exist. This is something I should go back. Corporations and LLCs often have rules, and they're either in an operating agreement, maybe in the articles, maybe in a shareholder agreement, that do not allow an individual who files bankruptcy to continue on with management duties. And in fact, this also is provided under California law. So even though I said the trustee could do these things, there are those restrictions that might exist. But to the extent the restriction does not exist, or the trustee is able to get around them, the trustee can do just about anything with a corporation as if the trustee were the managing member or the member or a shareholder. Finally, the last of the most popular business entities is the partnership, or LLP. Really, these don't offer any asset protection. Partners are generally individually liable, and if an individual partner is liable for something, the partnership assets could be reached. So really, this doesn't offer a whole lot as far as asset protection. Post-nuptial agreements. Post-nuptial agreements actually might work. There are some pitfalls. The first thing is that you need to have fair value exchange. If one spouse receives far less in value than the other, and that transfer can be unwound under 548 of the Bankruptcy Code or California Code Section 3439.04A1, which is actual fraud, and or under A2 or 3439.05, which is constructive fraud, which we call badges of fraud. That's just the common word for it. Of course, there are statutes of limitation, so to the extent there is a post-nuptial agreement that occurs, if it occurs long enough back, then the 4-year look-back window for avoiding fraudulent transfers could be avoided, and maybe these assets at some point become completely protected from creditors of a debtor or the bankruptcy estate, and specifically the trustee. There's one other little thing that's recently occurred, and that's the case of the Como versus Citibank N.A., which found that the trustee who would be stepping in the shoes of the IRS under 544B may be able to extend the look-back period for 10 years on fraudulent transfers. And this actually goes for any kind of transfer. So what this means is if the debtor has IRS debt and the transfer occurred during the period that the debtor had that IRS debt, or perhaps after, the trustee may be able to step in the shoes of the IRS, who might be a creditor at the time of the bankruptcy filing, and reach back 10 years to avoid a transfer. Okay, moving on. Marital settlement agreements. This is interesting. So as I indicated earlier, spouses rather, will often settle their divorce proceedings by dividing up assets. There are two cases on this that are of note. First is Mejia versus Reed. And in that case, the California Supreme Court held that property that is voluntarily transferred, so in other words, this is an agreement of the spouses and not a court order, where the property is voluntarily transferred under the marital settlement agreement, that transfer can be subject to avoidance under 343904 and 3439.05. And the reason would be if there's insufficient value. So if there's insufficient value exchanged, then the property received by the spouse who actually received more value, to the extent the other spouse ends up in bankruptcy, or potentially if a creditor is seeking to recover on a debt owed by that spouse who transferred the property away, the property can be recovered under California law. And to the extent necessary, Mejia versus Reed would also apply under 548. It's the same theory. It's if you have insufficient value exchange, which the Supreme Court in California has held that a marital settlement agreement may provide for that, something that's not sufficient in value, the trustee can unwind the transfer. Another case called Carbat, two cases, Carbat and Lamas, are very interesting. And in both of these cases, these are bankruptcy court decisions. And what this dealt with was a debtor and his spouse or her spouse entering into a settlement agreement, a marital settlement agreement, and the debtor agreed to transfer property, usually real estate, to the non-filing spouse in exchange for the debtor not having to pay support any longer to the spouse. And in Carbat and Lamas, both of the bankruptcy courts found that this was not sufficient value for purposes of avoiding the fraudulent transfer statutes. In other words, the legal requirement to pay support, which is something that's legally required in California to the extent it becomes applicable, because you're legally required to do this, the other party who is getting the asset really isn't giving up anything because you're still supposed to pay them. Now, maybe you don't have to pay them, but the way that these decisions read is that the waiver of spousal support is insufficient for purposes of showing fair value was exchanged for the asset. Okay, next, moving on to something that needs to be noted is looking at property when it is separate versus community property. And it's very important for bankruptcy purposes and perhaps when you're collecting a judgment to know how property is held so that you know whether or not it's subject to levy of a creditor or sell by a trustee. And as most of you probably know, the community estate of spouses can be held liable for any debt that's incurred by either spouse prior to or during the course of marriage. And this is regardless of whether one or both spouses have benefited from the debt. And this is actually found in California Family Code 910A. And this remains true even if only one of the spouses files for bankruptcy. The separate property of a married person, and this includes inheritances, is not liable for a spouse's debt incurred before or during marriage. The separate property, yes, of a married person is not liable for spouse's debt incurred before or during marriage. So that's the exception. But there's another exception to the exception, and that would be necessities of life. Those actually can be the amounts owed for food, shelter, clothing, court fees, and attorney fees can be collected against separate property of a spouse. And so for these rules, bankruptcy really doesn't change anything. So moving on, California law presumes that property acquired during marriage is community property. And that's found in California Family Code section 760. The presumption was for a very long time that community property, the presumption of community property rather, can be overcome. There's a clear statement in a title document that evidence of property is held as separate property and not community property, and that's Family Code 2581A. Recently, however, the California Supreme Court has ruled that title alone does not establish character of property during marriage. This is a matter of Emory Valley, and in that case, the Supreme Court of California rejected a line of cases that found acquisitions made during marriage by one or both spouses from a third party are exempt from statutes establishing how property can be transmutated from community property to separate property, And what you need to know is that Family Code Section 852A provides that a transmutation is not valid unless it's made in writing by an express declaration that is made, joined in, or consented to, or accepted by the spouse whose interest in the property is adversely affected. So under Valley, title is not alone enough to establish that property is held as separate property. You need to go through all of the requirements of Family Code 852A before property could actually become separate property. Otherwise, it could be treated as community property, and as most of you know, community property can be sold under 363, notwithstanding the fact that one of the spouses may not have filed bankruptcy. All right, Bitcoin. So Bitcoin, as I said earlier, they kind of advertise that everything is anonymous, but guess what? It's not all anonymous. Ownership of Bitcoin is actually held in a separate register offline, and Bitcoin, at least the company that runs Bitcoin, knows the owners of all of the Bitcoin owners. So a simple subpoena could be all that's necessary to determine whether or not an individual owns Bitcoin. Okay, unrecorded deeds. This one's tricky, and it actually was resolved yesterday for one of my cases. I believe Twan's on the phone. Good job, Twan. Okay, so property that is held but not scheduled. That's the first thing. If a debtor becomes into possession of a deed but fails to record it, it's likely that the property remains property of the estate because it's not scheduled. That's assuming the debtor doesn't schedule it, which, if it's consistent with what's going on, the debtor doesn't schedule it because the debtor doesn't want the bankruptcy court to know about it. And so it doesn't become administered, and since that's the case, later on, if the deed is recorded, the property still remains property of the bankruptcy estate. And that's important because sometimes disgruntled siblings, and in my case that was what happened, the sibling brought to the U.S. trustee's attention that their beloved sister was holding title to property from their mother, and she hadn't actually recorded the deed in order to hide it from the estate. Well, we learned about it because of the reporting by the beloved sister, and there was an order for turnover of the actual deed. That deed has been recovered and will be recorded, and the property is going to be sold. Even if that didn't occur, the question becomes whether or not any subsequent transfer of the property would be valid. Remember, if the property has not been listed and scheduled, it is has not been administered, so could be subject to administration years and years down the road, subject to the rights of BFPs. So similar to that would be undisclosed litigation or claims, which I didn't really note as an asset protection tool, but it's important for those of you who do not understand this concept to realize that anything that's not disclosed does not get administered. And what has happened a lot, and I've seen this in a variety of cases, is that later on the defendant, who the debtor has been suing, finds out that the asset's not listed. And then they realize, well, that means that the trustee is the only party with the right to prosecute the claim. And often they'll come to the trustee and say, well, let's cut a deal. But also what they will do is they'll tell the state court, look, the debtor didn't disclose the claim, so the debtor must think the claim is valueless. And even if the debtor doesn't think that, the debtor made a representation to the bankruptcy court that led to a discharge, and that discharge was based upon the disputes. And so now the debtor is taking a different position before this court, even though another court, the bankruptcy court, relied on the debtor's original position. And this is something called judicial estoppel. So what these state court litigants have figured out is that the debtor may be barred from pursuing a claim in a subsequently filed state court action so long as that claim existed pre-bankruptcy and was undisclosed. What they can do is seek some kind of adjudication of rights, usually summary judgment, that claim is no longer valid because the debtor is judicially stopped from asserting that the claim exists. All right, finally, the retirement plan, holding property by virtue of a default on promissory note. This one's a bit tricky. So as we all know, or most of us know, 704.115 allows an unlimited exemption for property held in a private retirement plan. But the face of the statute doesn't really provide a meaningful definition of what constitutes a private retirement plan. In fact, the definition is a bit circular. It says a private retirement plan means a private retirement plan union plan, or profit sharing plan. So the statute doesn't really require what a plan be, other than it needs to comply with the Internal Revenue Code, which really doesn't talk about what an individual retirement plan is anyway. But the Ninth Circuit says that private retirement plans must be designed and personally used for retirement purposes. But none of these cases really talk about a plan that's not IRC qualified. So the question becomes, if it's not in compliance with the Internal Revenue Code, does it actually qualify for the protections under 701.115? And I would say probably not. And this goes back to the Clark v. Ramaker decision, and it discusses the tax purposes of certain retirement plans and whether or not they can be shielded from collections. But setting that aside, really the bigger issue, the more likely problem with these, is that there really was an exchange of any value when the property was put in to the trust as a result of a, quote, foreclosure. And so, as I discussed earlier, anything done within 4 years of bankruptcy, or maybe 2, depending on what statute you're looking at, can be unwound under Section 548 of the Bankruptcy Code or 3439.04 and .05 of the California Civil Code. So even if this occurred, it's most likely that at least 4 years of a look-back applies, and if so, you could unwind the transfer. And then if there's IRS debt, you might even be able to go back 10 years. Okay, so those are all the real problems with asset protection tools. I'm going to go quickly through how you actually do these things correctly. One would be use your exemptions properly. Make sure you've selected 703 or 704 of the California Code of Civil Procedure. You get one but not both. Make sure you've maximized the use of those exemptions. Make sure assets are transferred to actually maximize the exemptions. There's nothing technically wrong so long as assets are being transferred from something held by the debtor to something held by the debtor, so long as the assets are put in something that is protected by an exemption. However, if you transfer property to a third party, obviously that may not be protected because it might be able to be avoided based under theory of fraudulent transfer. To the extent a property or asset has been transferred to a third party, you may need to unwind these transfers and then bring them into the debtor's possession so that you can claim the exemption and protect the asset. Finally, there's something that nobody seems to do, and that's where you have a debtor who is married but filing by himself or herself. That debtor, if they're going to be claiming 703 exemptions, needs to actually have a signed spousal waiver from the non-filing spouse. Otherwise, technically, the exemptions can revert to 704, which means that instead of protecting assets using the so-called wildcard exemption scheme, now you have 704 exemptions, and you could actually lose those assets because of that switch to the exemption. Now, I don't know what happens if you get the spousal waiver later, but that probably could fix the issue, but beware of that. That is a potential issue out there. Also, maximize what goes into retirement accounts. Put as much as you can per year that's allowable into the accounts. Be very careful about the maximum contribution limits. And don't let your clients or don't let debtors serve as a trustee or beneficiary. Well, I guess they're the beneficiary always, but the trustee of their own retirement plans. And insurance. Be careful with insurance. Certain insurance policies can be protected. Like I said, whole life insurance, not so much, but perhaps some of the insurance policy is exemptable. 529 plans also, those, although can be subject to avoidance actions, if you incrementally fund these things per year, they can be protected because they are no longer property of the debtor once the money goes into the plan. Also, property that's difficult to liquidate. These are interesting ones, and these are, I'm going to give you a little bit of what I believe to be tough things to sell as a trustee. One, timeshares. I never have and probably never will sell a timeshare. It's impossible. I think if you polled all the trustees on the panel in the Central District, they all tell you the same thing. Number two, alcohol. Any alcohol where the debtor doesn't hold a license is impossible to sell, and I was told once, illegal. So alcohol is an interesting asset, although it declines with value or consumption. The other one is marijuana. Marijuana is a difficult one because marijuana is technically something that's not recognized as something that can be sold under the United States law. So California is now permitting it, or at least it will be permitting it. But a trustee really can't sell marijuana. And there have been cases recently where trustees have been appointed to cases that have marijuana as an asset. It so far has been impossible to sell. Finally, vacant land. Vacant land's tricky. A lot of times vacant land is worth less than you pay for it. There are all kinds of problems with vacant land. That's an interesting asset that potentially would be a place to put money. But those are really the things that I find difficult to liquidate, at least. Doesn't mean that money is safe there, but those are things that you ought to consider. Wow, we have 2 minutes left, so I'm going to open it up for any questions, and I don't see any. I'm going to ask my assistant to take a look. Okay, we don't have any. We have 2 minutes left. I will let you all go to lunch early. Thank you very much for joining us. Again, a reminder, there is another webinar coming up next week. Have a wonderful week. Thank you all for joining us.